Today on Legalese, we need to talk about the Supreme Court's opinion in Murphy v. Missouri. Now, this was the case that challenged government censorship by proxy through the practice of what is known as jawboning. This is easily the most important Supreme Court case for this term, so you're going to want to stick around and get all caught up with me. Hey, greetings everybody, and welcome back once again to Legalese. As always, I am your host, Bob, and I want to thank you all so much for joining me here today. Now, if you happen to be new to my channel, let me especially welcome you. This is a podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, let me just remind you guys real quick, if you want to find out more about our show, you can go check out our homepage over at legalespodcast.com. And if you want to stay up to date whenever I post new content, because I don't just do videos on YouTube, I also post to alternative platforms. I write articles on Substack, I do show notes pages, and if you want to get notifications for some or all of those things, all you have to do is head on over to legaleshow.com, where you can subscribe to our newsletter. Let me know what kind of content you want notifications on, and they will be sent right to you. All right, we have got a whole lot to get to here today, and this is going to be my first of two videos. We have two very big cases going on today, so why don't we just jump right in? As I mentioned off the top, today the Supreme Court would issue their opinion in the case of Murphy v. Missouri. Now, unfortunately, this case came out exactly as I had predicted in my past Supreme Court round of videos covering this case at both the cert petition stage and following the oral arguments that were heard before the court. Now, in this case, the court threw out a lawsuit seeking to limit the government's ability to communicate with social media companies about their content moderation policies, with just 6 justices voting to reverse the Fifth Circuit, and 3 that would have affirmed the lower court. Now, the court ruled that the plaintiffs did not have a legal right known as standing to bring their lawsuit. So today we are going to very briefly review the important facts of this case, followed by my own summary of the opinion of the court. To truly understand this case, though, I would encourage people to go back and watch my past videos and or read my past articles that I have published on this case, since we have too much new information to get to here today to give you a comprehensive breakdown of the history. Furthermore, while I will be providing a summary that will cover the crucial details of the 68-page opinion of the court, as always, I strongly advise everyone to take the time to go read the full opinion of the court for yourself. Now, my articles and videos on this case, as well as a copy of the opinion of the court and other relevant documentation, can all be found on the show notes page for this episode, which, as always, will be linked down in the video description. And following our basic summary and analysis, I will spend the remainder of the video discussing the likely important consequences of this case moving forward on a number of issues, including Article 3 standing, the First Amendment, and jawboning. And why don't we define that term real quick, since many people are probably not familiar with what it is. So, jawboning is a term that is used to describe informal efforts by government officials to persuade someone outside the government to take action. Or, as I personally would define it, censorship by proxy. So, let's start with a brief look at the background of this case. Under their long-standing content moderation policy, social media platforms have taken a range of actions to suppress certain categories of speech, including speech they judge to be false or misleading. Now, in 2020, with the outbreak of COVID-19, these platforms announced that they would enforce these policies against users who post false or misleading content about the pandemic. The platforms also applied misinformation policies during the 2020 election season, and during that period, various federal officials would regularly speak with these platforms about COVID-19 and about election-related misinformation. For example, the White House, officials publicly and privately would call on these platforms to do more to address so called vaccine misinformation. Now, Surgeon General Vivek Murthy would issue a health advisory that encouraged the platforms to take steps to prevent what they called COVID-19 misinformation from taking hold. The Centers for Disease Control and Prevention alerted the platforms to COVID-19 misinformation trends, and they would even flag example posts. And the Federal Bureau of Investigation and Cybersecurity and the Infrastructure Security Agency would communicate with the platforms about election related misinformation in advance of the 2020 presidential election season, as well as the 2022 midterms. And in this case, the respondents were two states and five individual social media users who would sue dozens of executive branch officials and agencies, alleging the government pressured the platforms to censor their speech in violation of the First Amendment. Now, a federal judge in Louisiana ruled for the plaintiffs. U.S. District Judge Terry Doty agreed that federal officials had indeed violated the First Amendment by coercing or significantly encouraging social media platforms' content moderation policies. And Doty issued an order that limited the extent to which the White House and several other government agencies could communicate with these social media platforms. Now, the government would appeal this case up to the Fifth Circuit, and in the Fifth Circuit, they would largely uphold the ruling. They found the court held that both the state and plaintiffs and the individual plaintiffs had Article 3 standing to seek injunctive relief. On the merits, the court held the government entities and officials, by coercing or significantly encouraging the platform's moderation decisions, transformed those decisions into state action. And following the Fifth Circuit decision, the Biden administration would ask the Supreme Court to intervene. The judges would stay the order of the district court until they could review the dispute. And ultimately, the court would hold neither the individual nor the state plaintiffs have established Article 3 standing to seek an injunction against any defendants. So, why don't we briefly take a look at Article 3 standing and ask, what the fuck is that? Now, this is because obviously the majority opinion in this case turns on a lack of standing. So, we should briefly discuss the elements that the parties to a First Amendment related case such as this would have to meet to have standing. Now, Eugene Volokh wrote an excellent article over at the Volokh Conspiracy called What Does Murthy v. Missouri Tell Us About First Amendment Law that answers this very question. So, I am going to use the example he provided in his article. So he starts out with a hypothetical. He says, say you think the government is pressuring bookstores to take your book off their shelves. You want to get an injunction ordering the government to stop doing that. You acknowledge that the bookstores didn't violate the First Amendment because the First Amendment doesn't bind the bookstores themselves. But you are arguing that the government violated the First Amendment by pressuring these bookstores in this way. Now, to get the injunction, you would generally need to show four things, and this, I must admit, oversimplifies things somewhat, but it'll give you a very good idea. So, first of all, is what is known as traceability of past injuries. So, in our example, the bookstores have in the past taken your books off the shelves because of government pressure, and not just because they concluded on their own they didn't want to carry your book after all. Second is substantial risk of future injury. And here, the government is likely to act in a way that injures you in the future, which is important because you are seeking an injunction against future action. The third element is redressability. And for you to have standing, issuing the injunction in this case would have to be likely to prevent the harm. So, in our example, because the bookstore, freed from government pressure, would be likely to keep your books on the shelf, this injunction has, or it would have, redressability. And then finally, if you meet those three conditions, you have standing, at which point you move on to the merits. And in the merit stage for our hypothetical, the governmental pressure would have to be shown to indeed violate the First Amendment, for instance, because it would coerce the bookstores rather than just persuading them. So keep those four elements in mind as we read through the judgment of the court. Now, the court found that Article Three's cases or controversies requirement is fundamental to the proper role of the judiciary. A proper case or controversy exists only when at least one plaintiff establishes that he or she has standing to sue, i.e., that he or she has suffered or will suffer an injury that is concrete, particularized, and actual or imminent, and fairly traceable to the challenged action and redressable by a favorable ruling. And the Supreme Court found that here, in this case, the plaintiff's theory of standing depends on the platform's actions, yet the plaintiffs do not seek to enjoin the platforms from restricting any posts or accounts. Instead, they seek to enjoin the government agencies and officials from pressuring or encouraging the platforms to suppress protected speech in the future. And the court would go on to say the one step removed anticipatory nature of the plaintiff's alleged injuries presents two particular challenges. First is the principle that a federal court cannot redress injury that results from the independent actions of some third party not before the court. Second, because the plaintiffs request forward looking relief, they must face a real and repeated threat of injury. And putting these requirements together, the court said the plaintiffs must show a substantial risk that in the near future, at least one platform will restrict the speech of at least one plaintiff in response to the actions of at least one government defendant. So the court goes on to say that the plaintiff's primary theory of standing involves their direct censorship injuries, and the court first considers whether the plaintiffs have demonstrated traceability for their past injuries. Because the plaintiffs are seeking only forward looking relief, the past injuries are relevant only for their predictive value. The court goes on to say that the primary weakness in the record of past restrictions is the lack of specific causation findings with respect to any discrete instance of content moderation. And while the record reflects that the government defendants played a role in at least some of the platform's moderation choices, the evidence indicates that the platforms had independent incentives to moderate content and often exercised their own judgment. Additionally, the plaintiffs failed by and large to link their past social media restrictions with the governmental defendants' communications with the platform. And furthermore, the court goes on to obtain forward looking relief, the plaintiffs must establish a substantial risk of future injury that is traceable to a government defendant and likely to be redressed by an injunction against them. The court says that the plaintiffs, who have not pointed to any past restrictions likely traceable to the government defendants. Now, the plaintiffs also assert a right to listen theory of standing. The parties argue the First Amendment protects their interest in reading and engaging with the content of other speakers on social media. Now, the court found this theory, as they put it in their own words, startlingly broad. And the court would contend that it would grant all social media users the right to sue over someone else's censorship as long as they merely claim an interest in that person's speech. The court goes on to say while the court has recognized a First Amendment right to receive information and ideas, the court has identified a cognizable injury only where the listener has a specific and concrete connection to the speaker. Because they could not point to a specific instance of content moderation that caused them identifiable harm, they have failed to establish an injury that is suitably concrete and particularized. So now, if we plug in the court's judgment back into our basic model of the requirements for standing, here is what the court would essentially conclude. As to item one, which is traceability of past injuries, The court says there wasn't enough evidence to satisfy the majority as to these particular plaintiffs. As to item 2, which was a substantial risk of future injury, the court didn't think it likely that there would be enough similar future action by the government. And as to item 3, redressability, the court thought speech like that of the particular plaintiffs would continue to be restricted by the platforms, even if an injunction was issued. And because they failed on these counts of standing, the court actually didn't even reach the merits of this case, meaning it didn't make any ruling on the substance of the First Amendment free speech doctrine. Now, on the other side, Samuel Alito would issue a dissent joined by Justices Thomas and Gorsuch, in which they would make a case for why they would have granted Article 3 standing. In their dissent, Alito would make the point that, at the very least, one of the parties to this case, namely Jill Hines, had met the requirement for standing, with Justice Alito saying that the court could confidently connect the dots between the injury suffered and the relief sought by Ms. Hines. Something Alito points out is how the confusion of having multiple defendants, including both individual citizens and the two different states also suing in their sovereign capacity, caused the issue of standing for any individual party to become scattershot. Now, I would further argue that it's apparent that the best case for Miss Hines's standing was not made with as much care and factual detail in the briefs that were filed as it was in Justice Alito's dissent. And that dissent would state, and state quite correctly in my opinion, that the case could be one of the most important free speech cases to reach the Supreme Court in years, precisely because Alito would have ruled both that the plaintiffs had standing to bring their lawsuit and that the White House coerced Facebook into censoring at least one of these plaintiffs' speech. And despite the fact this case never gave any substantive ruling on the issue of First Amendment free speech doctrines, and the court certainly did not rule that what the government did here was legal, all the same, the restrictive approach to standing adopted by the majority might make it very difficult for victims of indirect government coercion to get their free speech claims into court in the future. And furthermore, Justice Alito's dissent succinctly summarized the sustained campaign of fairly brutal and vicious threats made by the Biden administration against Facebook during the COVID crisis from 2021 to 2022. Now, Biden threatened to break up Facebook with an antitrust suit if it did not greatly censor vaccine skeptic speech. Facebook merely complied because they had bigger fish to fry. But Alito would hold, and personally I would agree for what it's worth, that this was a clear violation of the First Amendment by the Biden administration. It was a gross misuse of presidential power that, at the time, was indeed a high crime or misdemeanor. Now, in my oral arguments video for this case, I went through the court documents from the discovery process of their cases that had come from the district court, and I read out some of the more egregious examples. Now, if you're unfamiliar with those particulars, you should definitely go check out that video because it is truly shocking at just how threatening and coercive the government got in their pressure on these social media companies. There is a broader problem here that goes far beyond the details of this specific case. Unlike direct government censorship, censorship through indirect coercion of media usually involves veiled threats and sometimes subtle communications whose meaning depends on context. There often will not be a smoking gun type evidence directly demonstrating a clear and simple link between the government's pressure campaign and the actions of media firms restricting speech. Now, that's especially likely in situations where firms also have content restrictions of their own, as is true not only of big tech social media firms, but also newspapers, websites, TV, radio stations, and so forth. And the same issue arises when it comes to whether a campaign of coercion is actually ongoing or not. Government officials involved in such efforts can make implicit but clearly understood threats without spelling them out in so many words. And that is particularly true if the relevant media platforms are subject to extensive government regulation, and officials therefore have many potential pressure points that they can use against them. So the fact is, if courts require very strong evidence of causal links plus an ongoing campaign just to get standing, government agencies can use that procedural requirement to escape judicial scrutiny of even very extensive indirect censorship. Now, that problem is likely to become more severe as agencies figure out the relevant standing rules and try to tailor their threatening communications to firms in ways that can exploit them. For example, instead of explicitly demanding a ban on the expression of a certain opinion, they could just demand more aggressive and systematic application of the social media firm's own supposed rules. And, as in some of the communications in this case, they could be very vague about the exact scope of their demands as well as the penalties for refusal. Similarly, they can also be vague about the exact time frame during which their demands would apply, thereby making it hard to get standing for relief against any future pressure. Now, the court's highly restrictive approach to standing in Murthy might be justified if it were clearly required by the Constitution, but the entire doctrine of standing is a highly questionable judicial invention with very little in the way of roots in the text and original meaning of the Constitution. Even if there must be some standing constraints on lawsuits, the specific standards of causation and proof of potential future harm addressed by the court here are, at best, judicially created precepts for the more efficient enforcement of constitutional requirements. They are not themselves mandated by the Constitution, but are rather rules of constitutional construction. The court would do well to modify those rules to reduce the risk of giving the government a tool to shield severe violations of free speech rights from judicial review. Now, there is one way in which this case can be seen as encouraging, and that is in regards to the still pending net choice cases that are before the court this term. This decision demonstrates an agreement among the justices that private firms such as social media companies have a First Amendment right to make content moderation decisions, and this augurs well for a correct ruling in the net choice cases, which will be coming out either later this week or really realistically next week. So stay tuned here to Legalese. And in fact, that's really all I have for you guys here today on Legalese. Thank you so much for tuning in. Now, you're definitely going to want to subscribe to the channel because I've got another video coming up later today on SEC v. Jarchese. We have an epic win in that case. You're really going to want to hear about it. So make sure to hit that subscribe button. And if you could take a moment and do all of those other things that help to trigger Al Gore's rhythm, I would greatly appreciate it. If you liked the video, hit that like button. If you disliked it, you can go ahead and hit that dislike button. Leave me a comment. Let me know what you thought about this episode or the topic we discussed or whatever's on your mind. I would love to hear it. So, anyways, until next time, this has been Bob for Legalese, talking about Murphy v. Missouri, and of course, as always, Cartago de Lenda Est.